Okay, because we have a full 2-hour program here today, and we thank you for joining us for this training. We'll get started. My name is Thea Butler. I'm the Community Engagement Manager here at Welfare Rights Centre, and I'm joined this afternoon by Senior Solicitor Donna Flood, who will be presenting the bulk of the training today. Our First Nations Access Officer, Alintia Weldon, will be supporting the chat and the questions and answers. We are recording this session, so you'll receive a link of the recording in a follow-up email. I'd like to begin with an acknowledgement of country. At Welfare Rights Centre, we acknowledge the traditional owners of the land where our office is based, the Gadigal of the Eora Nation, and pay our respects to elders past and present, both here and in all the countries that you are joining us from today. We extend our respect to all First Nations people attending this session. We acknowledge that sovereignty was never ceded, always was, always will be Aboriginal land. So we've sent out the slides for today's webinar in a reminder email, and you should have received that earlier today. Due to moving recently to Teams, we can't share these in the chat today, but we'll resend along with a link to the recording. Please use the Q&A to ask questions. This will help us to moderate questions and organise our responses. We'll be stopping several times to answer questions. We may not be able to answer all your questions due to time constraints. And please keep your questions broad. We can't give out legal advice today, and questions about very specific situations will not be answered. We may add links to external sites today in the chat, and we'll also be sending a useful links document in our follow-up emails. Sometimes the chat can get very busy. If that is irritating to you, please don't use the chat, but do use the Q&A to ask your questions. So Welfare Rights Centre is a community legal centre, and we specialise in social security and family assistance law. We provide information and referrals and legal representation to thousands of New South Wales residents each year who have a problem with Centrelink. Our peak organisations are Economic Justice Australia, Community Legal Centres New South Wales, and Community Legal Centres Australia. We work directly with Economic Justice Australia to advocate for law reform. We share our frontline casework experience with a national network of social security advocates to improve the social security system. And we recently contributed to a series of reports focused on the experience of women trying to access Centrelink in regional, rural, remote, and very remote Australia. And just one more reminder, I think I've gone through this slide. I probably messed up my intro, but today's presentation is general information only, not legal advice, and we can't answer any questions about specific circumstances. So keep your questions broad. And I'll now hand over to Donna.
Good afternoon, everyone, and thank you for joining us today. Just to let you know about what we're hoping to talk about and get through today, we're going to be talking about Centrelink payments and that basic structure and what the people that you're helping who are migrants and other newly arrived residents might have access to. We're going to be letting you know that there isn't a single neat, nice process. There's more than one rule for all of the payments that we're looking at. And there's more than one rule for all of the migrants who are arriving here in Australia. We're hoping that by the end you're going to be able to spot the exceptions that might be available for your clients that might give them access to a payment where otherwise it seemed that they would have nothing. And we want to spend a little bit of time focusing on how family and domestic violence can impact someone's access to a Centrelink payment or the payments that they may already be on. As has already been mentioned, it is legal advice. I am a solicitor. It is not legal advice. I am a solicitor, but I am not giving legal advice today. It is only information. So we were hoping to start with hearing from you. We'd be really, really interested in knowing what kind of issues you're seeing in your work and what kind of things that you're seeing, coming across your desk. If you'd be able to have a look at the poll that will hopefully have come up on your screen, that would be fantastic.
It's either on your screen or in the chat, and this poll will only allow you to choose one, so pick which one is the biggest issue for you. And I think if you can see this, the responses, what we're seeing is that understanding how the system works is primary. All issues of residency and visa category is taking over. And there's quite a lot of difficulty accessing expert staff and getting the same information each time. So I'm going to close that now.
All right. Thank you for that. It's really interesting to see both commonalities in what people are telling us and also those differences as well. So thank you. So when we're looking at trying to get access to a Centrelink payment, there are common criteria for all of them. For pretty much every payment that your clients are going to be trying to get, they need to prove how they have been financially supporting themselves in the lead up to that application. So looking at bank statements, they may need to provide a separation certificates from employment and things like that. They're also going to need to prove both themselves and their partner's income and assets as well. They're also going to need to prove their ID, and this can be a big problem for some people. So as can often be the case with migrants and newly arrived residents, they can have problems with proving their own ID. They are the ones that have the onus of proof to prove it. It's not Centrelink's obligation to go out and actually find the proof of ID for them, but you can ask Centrelink for help with proving your ID, and they have alternate ways that they can prove it. They can prove ID and both your commencement documents or your birth certificate. If you haven't actually proven your ID adequately, you can get paid for 4 fortnights without that proof, but it needs to be just a minor issue. You need to have at least given some sort of indication of who you are and just not have all of those documents that might be needed, and your payment might be cancelled after those 4 fortnights if you haven't actually provided the remainder of the ID proof that is needed. You can get an extension in some circumstances. So they are able to contact the Department of Home Affairs and to get to help you to get commencement documents or proof of ID as well. From there, sorry, just one moment. And if the Department of Home Affairs has assumed a date of birth when your client has entered Australia, date of birth may be unknown, then Centrelink is obliged to accept that date of birth on your Centrelink account. Now, with newly arrived residents and migrants, there are particular things that are unique to them that can impact whether they can get a payment or not. Visas are an incredibly big one, and that visa category is an issue that a lot of you are seeing coming across your desk. There's also waiting periods that a lot of migrants are facing, as well as their individual circumstances can also impact what eligibility they may have for a payment. So this is a flowchart that covers what we're going to be talking about today. At this stage, I'm expecting it to look like a mess of words that's quite confusing, but by the end, this should make a lot more sense, and this may just be a helpful chart for you to have so that you know that you're asking your clients the questions that you need in order to cover off everything that might be able to help them to get onto a Centrelink payment. So we're going to slowly go through this as the afternoon goes on. So common eligibility criteria for most Centrelink payments is that residency or that visa issue. So in order to get most payments, you need to be a permanent resident visa holder or an Australian citizen. You need to have been physically located in Australia when you lodge that application. You need to be intending to remain in Australia and for Australia to be your home. And when they're looking at whether you are a resident of Australia, then they're looking at how often you're travelling inside out of, and travelling outside of Australia, how long you're staying outside of Australia when you travel. They're looking at where you're staying in Australia. Is it temporary accommodation or do you have a settled place to stay? They're looking at what connections you have in Australia, if you've got business or employment ties to Australia and assets here and anything else that could be relevant to prove that you're intending to remain in Australia and that you are living in Australia and not just passing through. So some visas give you access to a Centrelink payment and others don't. So permanent residency visa holders generally get you access to a Centrelink payment, and temporary resident visa holders generally don't, but there are exceptions. Some temporary will give you access to a payment, and each visa number is classified as permanent or temporary. Every individual visa number has that different classification. There's no nice, neat, universal rule across all visas as to what payments you may have access to, because some temporary visas give you access and some permanent residency visa holders do not. One of the first things that we always do with all of our clients is ask them for their visa number and check. We will always just go and look. And there is a document, the link is at the bottom of the slides here. It's in the Social Security Guide, and it lists every single visa number and tells exactly whether it's a temporary or resident or permanent visa. It says what payments they may be eligible for. So if you have a look at that final column, that's the column you're looking at for access to payments, and it says not residentially qualified for a lot of them, but other ones there you can see the 060, the bridging visa F, has access to special benefit, family tax benefit, and other things as well. The 070 has a very similar access to payments. So you're going to be able to look up your client's individual visa number and will be able to check what they may be eligible for. Now, just because might have access to a payment doesn't mean that they're guaranteed to get it, because as with every single Centrelink payment, there are other eligibility criteria. You might need to be looking for work, you might need to be studying, you might need to be caring for someone, whether it's a child or someone else. There may need to be other things. There may be age requirements. So you're going to have to go and check each individual payment to see if your client matches those eligibility criteria beyond just whether they're residentially qualified. There are a whole load of barriers that just may not have anything to do with their migration status, their residency status. So when we're going back to that chart that we started with, then the first question you're looking at is what visa number are we looking at? And then what are those extra eligibility criteria that might be an issue? Yeah. And then we're looking at the other barriers. And one of the main barriers that we see people having is the waiting periods. So even if you have a visa number that gives you access and you satisfy those other criteria, then you might still have to wait before you can get access to a payment. And there are two main waiting periods that people who are newly arrived residents and migrants will face. One is the qualifying residence period, and another one is the newly arrived residents waiting period, and we're going to be going through both. So that qualifying residence period, the two that we see most commonly are the 10-year qualifying residence period for the age pension and for the disability support pension. So you need, even if you're an Australian citizen, even if you're a permanent resident, then you still need to have lived in Australia for 10 years over one or more periods before you can get access to a payment. And at least one of those time periods in Australia needs to have been for 5 years. Now, there may be exceptions available to you. There's no exception to the age pension. Yeah, you need to have been in Australia for 10 years before you can access to the age pension without any exceptions. But you may be able to get a different payment instead while waiting to get access to the age pension. You may be able to get special benefit, yeah, while you're waiting to get access to the age pension. But there is a newly arrived residents waiting period for special benefit, so you may not get it immediately. With the disability support pension, if your inability to work started after you got permanent residency in Australia, then you may be able to get access to the disability support pension earlier. But if your inability to work existed before getting permanent residency, then you're going to have to wait 10 years to get the DSP. But also, if you are a refugee or a former refugee, you have no qualifying residence period. So that is the one time where you don't need to think about that qualifying residence period, is if you are a refugee or a former refugee. So the newly arrived residents waiting period is the one that impacts more people because it impacts most social security and family assistance payments. It starts on the day you arrive in Australia or the date you're granted permanent residency, whichever is later. So you might have been in Australia for a number of years as a temporary resident, you get your permanent residency, your waiting period starts then. It doesn't start from the date you arrived. Okay? That time before becoming a permanent resident is irrelevant, yeah, for the waiting period. You can leave Australia while you're on the waiting period, that's fine, it doesn't reset. But that time you spend outside of Australia doesn't count towards that waiting period. And the payments that Centrelink offer have different waiting periods for different payments. So 4 years is the most common one. Most of those income support payments are a 4-year waiting period. You've got special benefit, youth allowance, job seeker or study. All of those. There's a 2-year waiting period for carer payment. There's a 1-year waiting period for the larger family tax benefit A, and there's no waiting period at all for family tax benefit B and the childcare subsidy. Okay. So, Carl arrived in Australia in March 2023. He travelled to Germany for a holiday in February 2024, came back a month later. He then went to Germany to care for his mother in December of that year, in December 2024, and he stayed in Germany for 12 months caring for his mother. His mother died in 2025 and he returns to Australia in December 2025. He can't get paid work after he comes back, and he lodges an application for a payment from Centrelink, and Centrelink says no, because he has a newly arrived residents waiting period. He can't access job seeker payment for 4 years. Now, he might have arrived in Australia 2.5 years before, but Centrelink have said that even though he arrived in Australia 35 months ago, he's actually only completed 22 months of his newly arrived residents waiting period because of that time that he has spent outside of Australia, and so he's not going to get access to a Centrelink payment for quite a few years, because it's a 4-year wait to get onto the job seeker payment, and he spent 13 months outside of Australia. Okay. So you've got newly arrived residents waiting period time, counts towards it, and that counts towards it, and that does, but all of that time out of Australia does not count towards that waiting period. Okay. So those questions that you're asking your client when they come to you for assistance or from help. So you're going, are you on an eligible visa? You're checking the website we sent with the link in the slides to check each of those, the visa number, to see what access they've got. Then you're going, are you eligible for the payment that you have chosen? You know, are you looking for work? If you're looking at on job seeker, are you a full-time student for Austudy? Yeah. Is there a qualifying residence period? Do you have that 10-year barrier to get onto the payment? Have you been here long enough? Yeah. Is there a newly arrived residence waiting period? Yeah, that 4-year, 2-year or 1-year wait, and have you been here long enough? Now, if the answer is no, they haven't been here long enough, it's okay, because there are exceptions. But before we get on to those, has anyone got any questions that they would like to ask or that they have asked?
We don't have any questions in the question and Q&A section.
Okay. We'll just keep moving unless we want to. Does anyone want to quickly write a question?
I think we should keep moving.
We'll keep moving. All right, done. So, as I said, there's exceptions to the newly arrived residents waiting period, okay? Not everyone who arrives in Australia actually has a newly arrived residents waiting period, even though the payment they're trying to get access to may have a standard 4-year, 2-year or 1-year wait. Some people never have to sit out that waiting period, okay? So if they've ever been a temporary humanitarian visa holder, refugee, or a family member of a refugee, or if they're Australian citizens. So Australian citizens have that qualifying residence period, but they do not have the newly arrived residents waiting period, okay? So they never have to sit out that waiting period. Yep. There are also exemptions to it, depending on things that have happened to them or that events that might have occurred since they arrived in Australia or since becoming a permanent resident. They might have access to special benefit if they've had a substantial change in circumstances, or they might have access to parenting payment if they became a lone parent when an Australian permanent resident. Okay. So if they became a lone parent before getting their permanent residency visa, they do not have access to this exemption. They only have access to this exemption if they became a lone parent after getting their permanent residency exemption. When you are a refugee, when you arrive in Australia as a refugee, you've also got access to a single payment of crisis payment as long as you contact Centrelink within 7 days of your arrival in Australia, and you apply for that crisis payment within 14 days of making contact. So, who is a refugee? You know, that's one of the big ones. Refugees are people who are granted a visa under the Department of Home Affairs humanitarian program. They can be granted those visas both onshore and offshore. And the visa subclasses we're looking at is the visas in the 200s and the 851CD visa. So if you go to that website with all of the visa numbers, you'll find in the 200s that it says access to all with no newly arrived residents waiting period applied. If you are a dependent family member of someone who is or ever was a refugee in Australia, you are also exempt. But not every family member of a refugee is exempt, only some. So you need to be the partner of the refugee, and you needed to have been the partner at the time they became a refugee. you need to be a dependent child who is in full-time education and is under 22 years of age, or you need to be someone who should be treated as a dependent family member for the purposes of not having to sit out this waiting period. So when you're thinking about that, you're thinking about, maybe they're over 22, but they're in full-time education and they can't work. Maybe they've got disabilities. Maybe they've got other reasons why they should be given this exemption to the newly arrived residents waiting period because they're dependent on this refugee family member. Maybe they're not a blood relation, but they are still should be treated as though they are a dependent family member. So you're looking at other possibilities about whether they should be sitting in amongst one of these three definitions, that partner, dependent child, or another person. And if you're found under this exemption, then you do not need to sit out that 4-year waiting period. You get immediate access to those Centrelink payments. Okay. So we've seen a large number of dependent family members of refugees apply for and try and access a Centrelink payment. It is their right to get the payment. They should be being granted these payments, and we've seen that a lot of people denied being able to lodge a payment. They can't even lodge a claim, or their claims are being automatically rejected because of that 4-year waiting period. So one of the things that it would be really, really, really important that you do to support your clients is to support them to get that application in, and if it's rejected, to lodge an appeal to an authorised review officer. Get that application in and tell the Centrelink Service Centre officer, that Centrelink officer at the counter or anyone over the phone, no, this person is a dependent family member of a refugee and they are exempt from the newly arrived residents waiting period, and the appeal needs to be looked at with that exemption in mind. Okay. So we have a case study for you to watch. Hopefully the sound is being shared. So I'm really sorry for those of you who weren't able to hear that video. When we're thinking about the situation and the scenario we just heard, those really important bits of information, those important facts that were told were things like, the client's in 21 years old and he's in full-time education. So he's under that 22-year cutoff for the dependent child of a refugee. We know that his father first arrived in Australia as a refugee and was granted a protection visa. Okay. He's got an older brother and he's got a mother, who neither of whom are on payment as well. Yeah. So what needs to happen there is for us, we're appealing that rejection that he had for trying to get access to youth allowance. We're saying, no, he's a dependent child of a refugee. He's under 22 years of age and he's in full-time education. He does not have a waiting period. There is no newly arrived residents waiting period for this person. His payment should be immediately granted and backdated to the date of application. But we would also be looking at telling him that his mother and his brother can contact us for advice. Because if his mother was his father's spouse at the time his father became a refugee, then she may be exempt from that newly arrived residents waiting period as well as a dependent family member of the refugee. And his older brother, depending on his older brother's circumstances, depending on his older brother's age, depending on a lot of things, there's a possibility that there's an exemption from that waiting period available for him as well. But we'd need to have a conversation with him to talk to him about what's going on. Okay. So we're back at this chart, and hopefully it's making sense. Hopefully it's looking like a really, a logical way of going through the issues that your clients are facing. What visa number are they on? Are there any issues with the payment that they're applying for that might be a barrier to them getting it? Is there that qualifying residence period? Have they been here long enough? Is there that newly arrived residence waiting period? Have they been there long enough? And are there any exemptions that might apply where that waiting period doesn't have to be sat out? Okay, so remembering, when you're on a newly arrived residence waiting period, if you become an Australian citizen, you no longer have a waiting period. It ends immediately on the grant of citizenship, but you still have that qualifying residence period, that 10-year wait, you still have that, but that shorter newly arrived residence waiting period is gone the moment you become a citizen. Do we have any questions as of yet?
We do. Molly asked, does the waiting period apply to someone on an 866 visa, permanent protection?
Yeah, sure. Yeah, I'd have to look. I look up every single visa number almost every time. I don't have every visa number memorized.
All right. And that's really it, because it's just about subclass 866 visa. And so I recommend looking at the visa subclasses and payment eligibility link, which is in the chat.
Oh, hang on. If that's the only question, I'm going to super fast look at it. 866. 866 protection has access to all payments and concession cards. There is a qualifying, there is a newly arrived residence waiting period exemption, and there is a qualifying residence exemption as well. So that is classified as one of the refugee refugee visas. So we should have had that. I'm sorry we didn't have that particular number listed on that earlier slide. All right. Okay, so there are exemptions to the newly arrived residence waiting period for special benefit alone. So you may have that 4-year waiting period for all of the other visas, but for special benefit, you might be able to get access to an exemption. So special benefit is that payment that you apply for when there are no other payments that you may be eligible for. If there's, you need to be in financial hardship, you need to be completely unable to earn your own livelihood for yourself, unable to get income for yourself, and you need to be in Australia the whole time that you are receiving the payment. The moment you leave Australia, the payment ends. You need to be an Australian resident or hold a particular visa. Now, it's usually paid at the job seeker or youth allowance rate. So it's one of the lower income support payments. So even if you're, say, of age pension age, it won't be paid at the age pension rate. It'll be paid at the lower rate. There is a really, really strict and quite harsh income and asset test that is applied. It's a dollar for dollar income test. So every dollar that you earn, a dollar of your special benefit is removed. There is also a short or long-term available funds test before you can get it. If you have liquid assets of $5,000 or more, then you won't be able to get access to the special benefit. It won't be paid. And if your liquid assets increase to $5,000 while you're on special benefit, then your payment may be cancelled. Okay. So that decision to cancel a payment due to the liquid asset test is a discretionary decision. And so you can ask for funds to be disregarded in some circumstances. So things like if your client receives the $5,000 leaving violence payment, You can ask Centrelink to disregard that, but there is no obligation on Centrelink to disregard it. It's a discretionary decision. They may choose to or they may choose not to. Okay. If someone has had significant liquid assets and they have been reduced prior to lodging an application for special benefit, then Centrelink may ask where the money went. How was it spent? And if they believe that a person has deliberately gotten rid of money in order to get access to a Centrelink payment, then they may deny access to the payment. They may say, no, you cannot get access to this payment because you've deliberately gotten rid of money in order to get access to it instead of supporting yourself on that money. Okay. There's other rules that might apply with getting access to special benefit depending on the applicant's age. So most particularly applicants who are under the age of 18 have different rules. Okay. So when you're trying to get access to special benefit when you're not a newly arrived residence waiting period, you need to also have had a substantial change in circumstances that was beyond your control that happened since arriving in Australia. Most cases it needs to have happened after being granted permanent residency, but also you need to be in financial hardship. So you're looking at someone who, after arriving in Australia and being granted permanent residence, something has happened. As a result of that thing, they're no longer able to financially support themselves. They're in financial hardship, and that thing that happened was completely beyond their control. Okay, so the sorts of things that Centrelink will consider is if their sponsor or partner has an illness, lost their job, died, if there's a breakdown in a relationship where there was domestic violence, if they had a child who has a medical condition, if a dependent child develops a medical condition, or if their sponsor or partner enters a long-term facility or incarcerated. So, Lamb had a minor heart condition. They had this heart condition years and years and years before arriving in Australia. It was repaired and they were considered to no longer have any cardiac conditions of any sort. As a part of their application for a visa to come to Australia, they needed to have a medical assessment and that was done. And then 12 months after arriving in Australia on their permanent residency visa, they develop a serious cardiac condition. They needed a bypass and they were told they needed to stop working. Okay. So they had a significant medical condition that was beyond their control that caused financial hardship and meant they were unable to keep working. So they applied for special benefit. Okay. They were rejected because Centrelink said that they had a pre-existing cardiac condition before they got their permanent residency and arrived in Australia. So in this situation, it was quite neat. They were able to get that medical assessment that was done by Australian doctors. That was a part of their migration process that showed that there was no cardiac condition at that time. They were able to present that as evidence to the tribunal and their payment was granted. Centrelink was found to have been in error in rejecting the application. So, those substantial change in circumstances have to happened after getting to Australia and usually after being granted permanent residency. But if there's family and domestic violence, and that family and domestic violence is the cause of the substantial change, so that breakdown in a relationship, okay, and that family and domestic violence happened after arriving in Australia and before being granted permanent residency, then it can be considered a substantial change for the purposes of qualification for special benefit. Okay, you just need evidence of that family and domestic violence, okay? And you need that relationship breakdown. Okay, so we had Mel contacted us when she was living in a refuge, in a homeless shelter. She was a teenager and she had to leave her home due to domestic violence. She was unable to return home because of domestic violence. But she was only on a temporary visa. She had no access to any payments whatsoever at Centrelink because of her visa status. So we referred her to Immigration Advice and Rights and told her to come back when she got permanent residency. She got her permanent residency, she applied for a payment and it was rejected because of the newly arrived residents waiting period. We contacted Centrelink and we explained that there was the family and domestic violence, a significant change in circumstance because she was no longer able to live at home. She had to move into a refuge. She was homeless and she was granted special benefit because the domestic violence started after arriving in Australia. So one of the other main exemptions that we look at is the lone parent exemption for newly arrived residents waiting period. And this is where someone became a single parent after arriving in Australia, but also after becoming a permanent resident. So you can get parenting payment, single youth allowance and job seeker payment depending on the age of your child. But the problem is, if you became a single parent before that grant of permanent residency, if you became a single parent when on a bridging visa or on a temporary visa, then you do not get access to the lone parent exemption. You may be able to get access in another way, but not through the lone parent exemption. Okay. So Zena arrived in Australia and met her future partner, Mike. They moved in together, they had children, and it was at the birth of their child, after the birth of their child, that Mike became more controlling and violent. On the day that Zena got permanent residency, Mike threatened their daughter. Zena had no independent finances of any sort. She had no income. She had no way of supporting herself. She had no way of supporting her child. And she had no idea how she would be able to leave. She didn't contact us until 18 months after getting her permanent residency visa, at which point we were able to advise her and support her, because from the moment that she became the permanent resident, there was no waiting period for family tax benefit B, no waiting period for childcare subsidy. Okay. If there was that breakdown of a relationship due to family and domestic violence, she would have had access to special benefit and would have also had access to family benefit A. But also, if she left Mike after becoming a permanent resident, then she would have been a lone parent, become a lone parent after getting permanent residency, and would have had access to that higher and more secure payment of parenting payment single. So she was able to access all of those after contacting us, but she actually had eligibility for 18 months before reaching out to us. Okay. So we've nearly reached the end of our flow chart. We've still got a little bit more, but hopefully this is making sense and it's becoming that logical thing. So we're looking at, is there that newly arrived residence waiting period? Have you been here long enough? Are there any exemptions? Has there been a significant change in circumstances, to give you access to special benefit, to give you access to parenting payment? Okay. Any questions at this point?
Yes, we have a question. Previously, it was stated that there are no other exemptions for the qualifying residence period. My understanding is that clients who have resided in a country that has an international social security agreement with Australia can sometimes have their required residency periods shortened by the number of years they spent in another country.
So when we're looking at applying for a Centrelink payment under the Australian Centrelink, system, there's a qualifying residency period. But if you have access to a Centrelink payment through an international agreement, that's a different system. And we're going to talk very briefly about that later, but that's a different system. Yeah.
And would that apply to the NARWP
and
as
whether
well?
you would be able to, and you're talking about maybe having that time in another country count towards your qualifying residence period. To tell you the truth, that's not something that I can answer off the top of my head at all, unfortunately. I try and know as much as possible. There are always things that I'm learning and having to look up, and whether time spent in a country we have an international agreement with goes towards a qualifying residence period, I don't know. If you have someone rejected in that situation, they can come to us for advice and we'd look it up and find it out, or you can just appeal the decision to an authorised review officer and get them to have a look. Any other questions?
That's it for now.
Okay, so we are halfway through and we're going to take a break now, and we will return in 5 minutes.
I think that makes it, yep, 2:55. We'll be back. So go and stretch your legs and grab a cuppa.
And we will be coming back with more ways to get access to a Centrelink payment when you may be on a waiting period, as well as all sorts of other things that your clients might be facing.
Great. Thank you. See you in a bit.
Welcome back, everyone. So we will keep going with different ways that your clients may be able to access financial support from Centrelink when they're a newly arrived resident or migrant. And one of the things that a lot of people don't realise is that if the person who's trying to access a Centrelink payment isn't eligible for any payments because of that visa number, so not necessarily because they're on a waiting period of any sort, but because of their residency, because of that visa number, then we really strongly recommend that you ask about whether their children are Australian citizens or permanent residents, because it may be that the child can get access to a payment when the parent has no access whatsoever. So the parent needs to be on a temporary visa rather than a permanent residency visa that gets access to a payment but has waiting periods. So the money goes into the parent's bank account. It doesn't go into a child's bank account. It goes into the parent's bank account until the child's 18 or until the child is considered independent and eligible for a Centrelink payment that's not special benefit, like youth allowance. Yeah. And that child's eligibility can change depending on their age and their living situation and whether they're enrolled at school or not. And the moment that the parent is granted a visa that gives them access to a payment, then that child loses their eligibility for special benefit because the parent becomes eligible or gains access to a payment. And that child's cancellation of a payment is considered a significant or a substantial change in circumstances beyond their control. So they will be immediately eligible to apply for special benefit with an exemption from the newly arrived residents waiting period because they lost the special benefit that was being paid to the child. Okay, so they won't have a break in payment. Their child's special benefit will stop, but they will be able to apply for and get special benefit in their own name. Okay. So we have, and for people who can't hear, I am so sorry. It's another 2 minutes of a case study that is an audio case study. So I am sorry about that. So thinking about that particular story that we were hearing, those significant things that we were being told was that they'd recently separated from their partner, that there was family and domestic violence, that they have a child who was born after arriving in Australia, they have no source of income, and they've been rejected for Centrelink payments. They're waiting for that permanent residency, but the child is an Australian citizen. Okay, so they're on that temporary visa. They're not on a permanent residency visa. So when we're thinking in the future, if they're granted a permanent residency visa, they won't have become a lone parent after getting permanent residency, so they won't be eligible for that parenting payment, that lone parent exemption. Okay. There is family and domestic violence, so that could be considered in the future after permanent residency for a special benefit application. That's a substantial change in circumstances. But more importantly, the child is an Australian citizen, and that child can get access to special benefit. It will be paid, the application is lodged on behalf of the child. It's lodged in the child's name, and the payment goes into the mum's account. But once mum gets that permanent residency visa, then she will be granted the special benefit because of that family and domestic violence and the breakdown of the relationship due to family and domestic violence, but also because they've lost the special benefit that was being paid to the child. So they've got two different things that are that substantial change in circumstance that will be looked at for a special benefit grant after they're granted permanent residency. So that's the end of this chart now. So hopefully it starts to make sense. Are you on an eligible visa? No. Do you have a child who is a citizen or permanent resident? Then yes, lodge an application in the child's name. Okay. But otherwise, if you're on the eligible visa, then travel through that pass, have a look at the waiting periods, have a look at the qualifications for the payment, have a look at those exemptions to the waiting periods, and if there's been that significant change in circumstances that might mean it gets you access, even when on the face of it, it looks like you don't. And even when Centrelink is saying you're not eligible because you have a waiting period, appeal that decision and show evidence that actually one or more of these things apply to you and you should be granted that payment. So have we had any questions?
Yes, we have.
Okay.
All right. So I do have a question just about if we could explain briefly the difficulty with New Zealand citizens in Australia being eligible for benefits.
So we do go into New Zealand citizens briefly later on. So what I might do is, if you've still got any questions after we talk specifically about New Zealand citizens, please pop them in the Q&A and I'll answer them at that point.
And Celeste has asked if this may be addressed later in the presentation, but wondering how these eligibility issues or exemptions may be impacted by the client being under 18 and on their own or unable to live with their family due to family violence, etc.
Yeah. Look, so if you've got a client who's under 18, then there are payments that they're eligible, that they may have access to. But when we were talking about those eligibility issues that are unique to migrants and newly arrived residents, age, the people that are under 18 have all of those other eligibility issues aside from that are unique to that. So if you're under 16, then as a general rule, you have no access to any payments whatsoever, but you can apply for special benefit. That's where the special benefit can be applied for. That's the only payment that you might be able to access. From 16 years and over, then you get access to youth allowance, and you've got those unique eligibility criteria for youth allowance itself. and that can get quite complex. So I'm not going to go into it now, but if you've got a client who's under 18, has applied for a payment and been rejected, then they could get legal advice from us or one of the other members of Economic Justice Australia around Australia, if you're not in New South Wales, who offer social security advice and could advise you on that. Just remember to appeal the decision within 13 weeks if you've been rejected for a payment, because that way you don't miss out on being back paid if your appeal is successful. Okay, so there's access to a payment due to when you're under 18 there's a whole load of issues going on there and a whole load of things that we do. We've previously done a 2-hour session just on youth and access to payments, so it can get complicated.
Okay. Someone has had a client who has worked and lived in Australia for 30 years, not an Australian citizen, married, husband, but has a lot of health issues. While they have a house in Indonesia, they stayed here due to the health system over there. They have been made redundant at work and in early 70s, and I can't figure out if they qualify as a resident.
Yeah, fair enough. Look, my first question would be, what's their visa number, and look that up. Yeah. So that would be the first thing that I would suggest you do, is ask them what visa number they are on and look it up on that link in the earlier slide and go from there. Yeah, because the advice that you give will change depending on that number and what's floating around there.
All right.
But my advice often is just lodge an application, test your eligibility, just get them to apply for a payment. Yeah, and test it. Get Centrelink to look it up. Centrelink to figure it out.
Right. And another question, I understand international students must prove they're able to support themselves while studying in Australia, but are there any Centrelink payment support available for student visa holders for special circumstances? New health diagnosis, change in financial support from overseas, etc.
Yeah. Look, as I said at the beginning when we're talking visas, I look them up every time. Even ones that I think I know, I'll look it up, because there are hundreds of visa numbers, and as a lawyer I will always make sure that my advice is correct rather than thinking I know. So I don't know. I will not give you advice on individual visa numbers for students because I actually don't know what those visa numbers are, and I'd be looking it up every time myself. So ask them a specific visa number and look it up and see.
All right, that's it for now.
Okay. So I wanted to talk now a little bit more about family and domestic violence in particular, and how family and domestic violence can impact Centrelink payments. Now, with obviously doing this with a specifically thinking about migrants and newly arrived residents, but actually what we're talking about covers everyone trying to access a Centrelink payment or who is currently on a Centrelink payment. So any change to the relationship status can impact payments. Whether you're in a relationship or not can impact payments. Okay. How Centrelink define family and domestic violence is really, really, really important to understand, because family and domestic violence to Centrelink isn't just physical violence. Okay. And it isn't just within an intimate partner relationship. It is between relatives, guardians, flatmates, friends, former friends, is family violence. Domestic violence is that intimate partner relationship. But when we're looking at the forms that family and domestic violence can take, then you're looking at emotional and psychological abuse, you're looking at financial abuse, you're looking at using systems to cause harm to the other person, including using Centrelink in order to inflict harm on another person. You're looking at neglect. You're looking at exposing children to these behaviours. They are all forms of family and domestic violence, okay, according to the definition that Centrelink has. Okay. So if you're in a relationship, it impacts what rate of payment you can get. It impacts whether you can get a payment at all. It impacts those income and asset tests. It impacts in a lot of different ways. Okay. And when you're a member of a couple and there's family and domestic violence, you can see things like someone didn't declare they were in a relationship. Maybe they didn't declare the income and assets of the partner to Centrelink. Maybe they might have declared everything, but that perpetrator isn't providing them any financial support at all. Okay. Might be that the perpetrator is stealing money. It could be that they just didn't know they needed to declare it because they didn't realise that it was a relationship according to Centrelink. Yeah, didn't realise it fits the Centrelink definition of a relationship, or it just might be on again, off again, on again, off again. Okay, so when you're talking to your clients and you're trying to work out whether they're in a relationship or not, then on the left-hand side there, those are the 5 things or the 5 areas that Centrelink are looking at to determine whether you're in a relationship. They're looking at the financial relationship, the financial aspects, all the different financial things that are in there. They're looking at how the household works. They're looking at how they're organising the rooms, how they're organising the housework and things like that, what those dynamics within the house are. They're looking at that public facing aspect of the relationship. Are they presenting themselves as in a relationship to the public, social situations and things like that. Sex is one of the 5 things, but it's not the only. Just because they're having sex doesn't mean they're in a relationship. But they're also looking at what their commitment is. Do they feel obliged to support each other? Are they making long-term plans together? Okay. If you want to know more about exactly how Centrelink make decisions about relationships, down the bottom of this slide are 2 links to 2 fact sheets. The first one is from Economic Justice Australia, and it has a really good list of questions that you can ask your client. And then the second one is a really clear fact sheet on our own website that you can go through as well. But the important thing about this slide is the family and domestic aspects of those 5 things, because you might find that they actually fit the definition perfectly for all of the things on the left-hand side, but there's family and domestic violence, and they might, and Centrelink will go, okay, if there's financial abuse and coercion and threats, then maybe we don't see the financial aspects of the relationship, and we go, maybe actually those things aren't there, Maybe even though the nature of the household appears to show that there's a relationship, but it's been distorted by that family and domestic violence, yeah? Or maybe they're doing that public facing of being in a relationship, but it's not really a true reflection of what's going on, yeah? Maybe that sexual relationship is forced, or maybe even though they seem to be showing commitment, there's just no genuine commitment because of the coercion, threats and domestic violence, okay? So we've got Maria. Maria's a full-time stay-at-home mum. She's been in a relationship with Bill in Australia for 3 years. She doesn't get any Centrelink payments because Bill's income and assets are over the Centrelink limits. But she has no access to the money, to the assets, is completely powerless, is given minimal money for groceries, and she actually needs to rely on charities in order to access food vouchers and hampers because she just can't afford to support the family. Okay, she wants to work, and Bill reacts with anger, and she's trapped. Okay, so she's unable to escape and end the relationship because of that financial dependence on Bill and because of that fear. So Centrelink, because of the nature of the relationship, might decide that even though she appears to be in a relationship, she's actually not. And they may treat her as though she is single, even when she's in a relationship, or they might decide that even though she's living in the same house as Bill, she should be considered as being separate and separated. Okay. So we've got the appearance of financial support. We've got that no separation of household tasks. We've got them sharing a bedroom. We've got her seeing as herself as in a relationship and presenting herself as to the community that show that she's in a relationship, but there's financial abuse. There's no support from the financial support from the partner. Okay, she's having to use vouchers. There's the physical violence. Okay, and there's the isolation. Okay, that Bill is causing is creating that isolation, and that goes towards them being seen as not in a relationship. So if you've got a client who's in a relationship but isn't getting any support from their partner, okay, isn't being, you can ask Centrelink to consider them as being separated under the one roof, or you can ask for something called Section 24. Now, Section 24 is the one and only time that you'll ever find any of us talking about a section of the legislation. For some reason, Centrelink has decided to call this a Section 24 application. Okay? And Section 24 is a part of the legislation that says that even if someone is in a relationship, Centrelink has the discretion to treat them as though they are single and pay them as though they are single. So you can lodge applications for both of these. There's a form that's available for the separated under the one roof application, and you'll be able to find that form at that link. There is a section of the form that you can tick that will indicate that there is family and domestic violence, so that Centrelink will not let the other party know what's happening. And you can just ring Centrelink and ask that a Section 24 application be lodged and that they are supported to lodge a Section 24 application. Okay. So that's when there is domestic violence and they're not able to get support from their partner, but they're in a relationship. Okay. Now, you can also use that Section 24 when you have a client who has been dropped down to the partnered rate of Centrelink. So when you're getting a Centrelink payment, a lot of payments have a single rate and a partnered rate, and that partnered rate can be significantly lower, hundreds of dollars a fortnight lower than the single rate. And if you have someone who has partnered, but their partner is on a visa that doesn't permit them to work in Australia, that their partner is unable to access a Centrelink payment. Their partner is completely unable to financially contribute to the relationship in any way. They can't work, they can't get a Centrelink payment, they don't have their own income and assets of any sort. Then you can ask Centrelink to treat the person on a Centrelink payment as though they are single, even though they're in a relationship, because they're not getting the financial advantage of being in a relationship, and they are they're having to support the two people on that lower partnered rate. So once again, it's a phone call to Centrelink and ask that Section 24 be considered. So crisis payment is another one of those payments that people often associate with family and domestic violence, and it's an important one to remember. It's a fairly low payment, but it's a very important one to get. So it's available when the family and domestic violence victim has been forced to leave the home, or where the perpetrator has been removed from the home. It's also available to people who are recently homeless or recently released from prison. And as I mentioned earlier in the session, if you are a recently arrived refugee or humanitarian visa holder, you can contact Centrelink within 7 days of arrival and then lodge an application within 14 days of that, and you'll get that one-off payment as well from the day you arrive. For family and domestic violence, you can lodge up to 4 applications in 12 months. So it's not a calendar year, it's that 12-month period. Social workers make the assessment, and the client needs to be able to be contacted by phone. So they need to have access to a phone so that Centrelink can ring them, right? So when you're contacting Centrelink, it needs to be really clear that you're contacting them about the crisis payment, yeah? So you need to be contacting Centrelink and telling them, I want to talk to you about the crisis payment, okay? So time limits to get crisis payment are really, 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 really strict. You have to contact within 7 days of the perpetrator being removed from the home, or within 7 days of the victim's survivor deciding that they're not able to return home and that they have to set up a brand new place of residence. Okay, it's not 7 days of leaving the house. It's 7 days of realizing that you can't return to the house. Okay, then you need to lodge the application within 14 days of contacting Centrelink, and you need to be showing evidence that you're eligible. So either the AVO because the perpetrator's been removed and can't come back, statements from support workers and doctors, or something from to show that you're intending to establish a new home, something from a refuge and things like that. Okay, be aware that the perpetrator might also be eligible for crisis payment as well. You might need to support your client in understanding that they may have eligibility as well. So when you're looking at proving that family and domestic violence and that eligibility for crisis payment, get documents from the police, and the courts, get letters from doctors and counsellors. Friends, family, yourself can make personal statements and statutory declarations. You're going to need identity documents, okay? You're going to have to make sure you update personal details like phone numbers, bank accounts and addresses. And you're going to need to show all that eligibility information like income and assets and how you've been supporting yourself. Okay, so you can't get crisis payment when it's an ex-partner who's not living with you, that has returned and been told they need to leave, that doesn't no longer lives with you. You can't get it when it's someone who just regularly sleeps over. You can't get it when your income and assets are over any eligibility limit, and so you're not eligible for an income support payment. And you can't get it if you don't comply with those waiting periods. They're really, really, really strict, contacting within 7 days and applying 14 days after that. Okay. So if you've got a client who's on the family tax benefit, then there is also some significant impacts that family and domestic violence can have as well. If you're not estimating your income correctly, if the ex-partner doesn't do their tax return, if an assessment of child support means that your family tax benefit eligibility is reduced, but you're not getting the child support payments, or if there's these constant changing in what days the kids are staying with whom and how much care you have of the kids, okay? Because who has the children will impact the rate of payment, it will impact what payment you can get, and it will impact that percentage of payment you can get for family tax benefit, not parenting payment, but family tax benefit. And if that child is removed from your care by the perpetrator and there's been no consent, then you may be able to keep getting payment for a brief time, but only if you're telling Centrelink within 14 days of any change in circumstances. And if you want more information about how how many nights a week that child is staying in which house can impact that percentage of care. There's a link there that you might want to follow to get some more information. And if you want more information about what to do when there's disputed care, you know, whether there's a dispute over who has the child, then follow that link and there's some more information there as well. One of the things that we see a bit and people often don't realise is a problem is that when you have, when you're receiving the family tax benefit and you are not living with the other parent of your child, then you have to lodge an application for child support. It's called taking maintenance action. And if you don't apply for child support, then your family tax benefit will be reduced. And it will be reduced a really significant amount down to the base rate. Now, if there's family and domestic violence and there is a fear of retribution, if you were to lodge an application for child support, then you can apply for an exemption for that requirement to seek child support. If you are going through the child support agency and the child support agency has made an assessment of how much child support you should be getting, and that amount of child support is high enough to reduce your family tax benefit in any way, but you're actually not getting the child support's not being paid. So your family tax benefit's dropped, but you're not getting the child support, then you can ask Centrelink to pay you the family tax benefit based on what's called the disbursement method, which is where they pay you family tax benefit based on the amount of money that's actually going into your bank account rather than the amount of money that the parent of your child should be paying in child support. Okay, so both of those things are conversations with Centrelink. They're not a form to be filled out or anything like that. It's giving Centrelink a call, having a conversation, asking for a social worker to be involved and asking for a social worker to make that assessment about whether you should be on an exemption or whether that entitlement versus disbursement method should be used in calculating how much family tax benefit you're meant to be getting. Okay. So another thing that it's really important that you guys remember, because it can make a really significant financial difference and can make a really significant difference in access to being able to, say, work or study, is that there is an additional childcare subsidy top-up available to some families over and above the standard amount of childcare subsidy that people can access. So if you've got a family where the child is at risk of serious abuse and neglect, where the grandparent is the principal carers, where there's temporary hardship, or where they're a low-income family that's transitioning from a Centrelink payment into work, then they may be able to get an extra 100 hours a fortnight of childcare subsidy, and the actual dollar amount of the subsidy can be up to 120% of the normal dollar amount per hour that is paid in childcare subsidy. So it's a really, really important thing to be aware of to get your clients access to, because an extra 100 hours a fortnight can make a significant difference to working and to study. Okay. If there's family and domestic violence as well, then you might be able to find that you might be able to get your client access to an exemption from their mutual obligations or those compulsory activities that they have for job seeker payment, okay, or youth allowance. So if you're homeless, If you're living in a refuge, if you're having to move constantly, you can get an exemption from mutual obligations. If there's a crisis of some sort, if there's family and domestic violence, and for other reasons as well, you might be able to get your client an exemption from those mutual obligations, that temporary exemption. Okay. So, other issues that your clients might be facing other than family and domestic violence and Centrelink. And I realise there now might be a good opportunity to just quickly briefly stop for questions just in case there are any, because we're changing subject.
Yeah, perfect. I was just thinking, why didn't I put a question slide there? Okay, we do have one question. I've answered a very specific question in the chat, but in the questions, but this one is about what if both parents were on a temporary visa and a child was born in Australia, but mum had to leave because of DV? Would the child be considered a citizen? And would mum be able to get a lone parent payment?
So if she's on a temporary visa when she becomes a lone parent, then no, there is no lone parent exemption. That lone parent exemption is only available when you become a single parent after your grant of permanent residency. But as to whether the child would be a citizen, it's the problem with talking to a Social Security and Family Assistance lawyer. I'm not an immigration lawyer. I don't know what that child's immigration status would be. Yeah, I don't know whether they would be a citizen or not if they were born in Australia. You'd have to ask an immigration lawyer.
Thanks. That's it.
Cool. All right, we'll keep going. Okay, so this is one of my favorite documents. I have a copy of it sitting on my desk next to me at all times. It is Guide to Australian Government Payments. It is the really, really, really good resource for checking whether your client is receiving the payments they're entitled to. So in it, you're going to find the typical amount that people would get on a particular payment. So you'll be able to go, oh, you're on significantly less than that. Let's see if we can figure out why. It'll give you the income and asset tests for all the different payments, and it gives you a whole load of the different eligibility criteria for each of the different payments. It changes every 3 months, so you do need to make sure you've got the current guide for the current numbers, but it's just a really, really handy document for double checking that your client is actually receiving all of the money that they're entitled to, that there's no weird deductions happening, or that they've not been put on the base rate for family tax benefit, they're not on a partnered rate instead of the single rate. All of those sorts of things you're going to be able to check from this guide. Now, we mentioned earlier about international agreements. So there are a number of different countries that we have international agreements with, and countries are added every now and again. New agreements are reached every now and again. So it's worth going back and just checking when you have a client to just make sure. Now, if there is an international agreement with another country, it means that a person who is a citizen of another country but is not on an eligible visa in Australia may be able to access a social security payment while in Australia through that agreement. But it also means that if they are in that other country, they may be able to access an Australian payment while in that other country. Now, it's normally age pension, DSP, but it can also be carer payment and other payments as well. You are usually only able to receive the payments when you're in Australia or the agreement country. If you're in any other country, then your payment is usually suspended or cancelled, and you might be able to get a payment in Australia when you're on a qualifying residence period through that agreement rather than waiting out the 10 years to get access to age pension or DSP in Australia. Okay. There is a link there on the slide to where all of those agreements are listed that you can follow as well. And look, I can't give you a nice, neat understanding of what all the international agreements do provide you access to, because every single one of them is different. Qualifying through those agreements is different under every international agreement. We have to look it up, and we have to look at every one of them individually every time we advise on them. Okay. New Zealand citizens are their own special category of people getting access to a Centrelink payment. So when New Zealand citizens come to Australia, they're automatically granted a special category visa, the 444 visa. Okay. If you arrived in Australia before the 26th of February 2001, you have different rules. Okay. I won't go through them now because most people we advise arrived in Australia after that date. So as a New Zealand citizen, you're eligible to live here permanently. You can do any work that you desire. There's no restrictions. You have to pay Australian taxes and you're eligible for Medicare. But you have no access to Centrelink payments. There are some exceptions, but they are very, very limited. Okay, so age pension. You can get age pension through the New Zealand agreement. Okay. But you need to have had 10 years residence in either Australia or New Zealand or both combined. When you're in New Zealand, that 10 years had to have been when you're working age. Couldn't have been when you're a child. But time in Australia can have been at any age whatsoever. Okay. The disability support pension, you can get access through the New Zealand agreement, but it's a lot harder to get the DSP through the New Zealand agreement than the Australian rules. And we know that getting it through the Australian rules is very hard, and through New Zealand agreement, it's even harder. Okay. And if you are partnered with a DSP recipient and you're caring for them, then you might be able to access carer payment. Other than that, you can get 6 months of youth allowance or job seeker. But to get that, you needed to have lived in Australia for 10 years. You can only apply for it once. If during those 6 months you lose eligibility and that payment stops, you can't apply for and get the remainder at a later date. It's once in your lifetime, once only that it's ever granted, and you can't, and that's it. It's the only time you'll be able to get that particular payment. Now, we did have a New Zealand questions earlier. Did that answer your questions? Great, thank you. Okay. Okay, so other things you need to be considering, okay? If you may be able to access a foreign pension or some sort of you've got income or assets overseas, then Centrelink can require that you apply for that pension, and any money or assets held overseas are income and assets for Social Security purposes. Okay, so if they discover later on that you actually had income and you had income coming from overseas, or that you had assets held overseas that you didn't tell Centrelink about, they can raise a debt. Okay, if those assets would have impacted the amount of payment that you got. Okay. Now, we've sort of reached the end of access to Centrelink payments, but we wanted to let you know about some other financial support that your clients may be able to access. So if you can't access Social Security payments, there's a possibility that you might access what's called the SRSS payment or the Act of Grace. Okay, so the SRSS payment is a Status Resolution Support Services payment. It is only available to people who hold the Bridging Visa E, no one else. So you need to have applied for a temporary protection visa or a safe haven enterprise visa, and you need to be having difficulty trying to resolve your immigration status. So you need to access it only through particular organisations. In New South Wales, those organisations are Life Without Barriers and Settlement Services International. If you are not located in New South Wales, I don't know whether those organisations are the organisations you need to be contacting, but you can Google and look up Status Resolution Support Services for more information. Okay. Now, the Act of Grace is a discretionary payment through the Department of Finance. It's not through the Department of it's not through Services Australia, it's not through Centrelink, it's through the Department of Finance. It is seriously a last resort remedy. It can be a one-off payment, but it also may replace an income support payment. So you may get regular payments for a period of time in place of a payment from Centrelink. You need to have exhausted all other options of getting financial support, both from within Australia and from your country of origin or any other country that you may be able to get a payment from before an Act of Grace will even be considered. And it's only paid when there's special circumstances. And they will review it periodically. It's not a lifetime payment of any description. It can be reviewed periodically. So if you're not, if an access to, if your visa status is one of the things that is a barrier to getting a payment through Centrelink, and you're not trying to, change your visa status, then they may go, no, we're reviewing this and we're not going to let you keep receiving this payment. So it's a tricky one to get. It's transformative. It's life-changing if you can get it. And it's important to know that it exists. Okay. All right. So if you get a decision from Centrelink, so you've lodged an application and they've rejected it, they've dropped your payment from the single to the partnered rate, all of those sorts of decisions, you can appeal those decisions, okay? But not all decisions should be appealed, because if you have a debt, we always advise you to not appeal a debt until after you have legal advice, because debts can increase on appeal. You might find that you're assisting your client to appeal a $1,000 debt and they return to you with a $12,000 debt. So get advice before you appeal a debt, but most Centrelink decisions can be appealed, and we often recommend that you do appeal them, just not debts. Okay, but there are time limits to lodge those appeals. If you've been rejected for a payment, then if you appeal within 13 weeks and you're successful, you get back paid to the date that you lodge your appeal. But if you don't appeal within 13 weeks, even if you're successful, you won't be back paid. You'll only get back paid to the date you lodged your appeal. So this is a really, really important thing to take note of, those time limits that are there for lodging an appeal. There is no time limit to appeal a debt, no time limit. Don't appeal a debt without getting advice first. But if you're trying to get your client onto a payment and their application has been rejected and you think that they should have an exemption from a newly arrived resident's waiting period or something like that, get that appeal in within 13 weeks so that they can be back paid. It's really important. So, key things to take away. Get your clients to test their eligibility, even if the Centrelink officer behind the counter won't even let them lodge an application, or even if the Centrelink officer says, don't bother, you've got a waiting period, come back in 4 years. Okay, test your eligibility even when Centrelink says they're not eligible. Okay, if they've been rejected for a payment, get that appeal in within 13 weeks so that they can be back paid and come to us or one of the other different specialists in social security law around Australia. Okay. If you have a client who is experiencing family and domestic violence, it's really, really important to support them to keep them safe or keep their information safe. Because if you don't change your information at Centrelink and other government departments in the right order, then the perpetrator may be informed as to those changes and may get access to new bank accounts or new names or new addresses. Okay, so this is a really important slide to go through so that you know that you're actually changing things in the right order to protect your client. Okay. Now, if you have a client and you're trying to support them with Centrelink, then there are a whole load of different services that Centrelink offer that may be of assistance. You've got lots of information, not all of the information, but a lot of information in other languages. You've got the multilingual phone service that you can access a translator through that telephone number there, and also they may be able to do an assisted claim through that number if they're unable to do a claim online or on paper. Community workers can also contact the multicultural service officers on behalf of their clients. Clients cannot contact the multicultural service officers themselves. Only community workers can. Okay. And you can also be authorised to talk to Centrelink on behalf of your client. Okay. And there is a particular form that your client can fill in, authorising you to talk and act on their behalf as well. If they're struggling with digital literacy and accessing online services, there's digital coaching available as well. Yeah, go Thea. You're on mute, Thea.
We just have a couple of questions. I thought we'd jump in
brilliant.
now.
Fabulous.
Okay, so here we go. A single mother who's currently working and earning approximately $81,000 per year receives payments for her children and also caring for her older daughter who does not have a concession card. Could you advise whether she may be eligible for a healthcare card or any other concession cards or assistance based on her family circumstances and income? I think it's
No.
back to visa.
No, I can't. I wouldn't be able to. There are too many other questions I'd want to be asking. Also, are you when you're talking about her, are you talking about the mother getting access to a payment or the daughter? Because they both might have different answers. So yeah, unfortunately, I wouldn't be able to answer that question.
Okay. And are there any payments available from Centrelink for mental health? I think it says mental health consumers, but I think it might be people who are experiencing mental health issues on a bridging visa with multiple complexities.
So the first slide that I used for talking about visa numbers happened to be the list of different bridging visas. So you need to be asking your client which bridging visa they're on, then looking up the list and seeing what access to a payment they may have. There is very limited access when you're on a bridging visa. From memory, it's only bridging visa E and F, but don't quote me on that. I would be looking it up every single time. If you have someone who has significant mental health issues, who is, as a consequence of those significant mental health issues, they are unable to work, they have an inability to work because of those financial issues, then depending on when that inability to work arose and depending on what their visa number is, they may be able to have access to the disability support pension. But once again, what's their visa number? And they may be able to access a payment through an international agreement. But bridging visa, look up the number first. Look up the visa first. They're the O ones, the 010, 020, 060 from memory.
All right, and that's it.
Okay, so If you have a client who has experienced family and domestic violence, then they may be eligible for a up to $5,000 in financial support, and they can access that through the Leaving Violence program. There's a link there on the slide. If you have a client who is a refugee or an asylum or seeking asylum, then there is a link there as well for different supports and information that may be helpful for them as well. If you would like to contact us, if you would like to refer one of your clients to us, we have a telephone line that is open on Mondays and Wednesday mornings from 9:30 until 12. That's the telephone number there. But I'd actually probably recommend that you refer your clients through the website, the Contact Us page on the website, or through email. And there is a link there to a PDF that is a referral guide for referring clients to us, so that you know who we would be able to assist. We cannot assist everyone who contacts us. It's why we do these, it's one of the many reasons why we do these education sessions, because we are a small organisation, we have limited capacity, and we can't help everyone who has a Centrelink issue. So we try and provide as much support in other ways as we can. We are hoping, well, it's not a hoping, it's happening. There will be a national social security advice line that is specifically for community workers. It's going to be opening this year. We don't have an exact date that it will be opening. It will be, it's going to be run by members of Economic Justice Australia, us being one of them, and you will be able to ring that telephone line to get information and advice provided by one of the Economic Justice Australia members. But you will only be able to access it as a community worker. It is not for clients. Clients will be referred out to the individual centres for advice and assistance. Okay, so we've also got a whole load of information on our website. Okay, so there is a lot of information, a lot of fact sheets, a lot of links, and a huge amount of information on our website that you can access at any time as well. And we want to, there's also just popping back there, there's also links to previous training that we have provided as well, and to videos of previous education sessions that we have done as well, that we recorded at the time and have uploaded onto our website. So if there are other subjects that you think you would like to learn more about with regards to social security law, please have a look on our website. We'd like to thank these organisations for funding us as well to provide these education sessions. If you want to keep up to date with changes in social security law as well as different things that we're doing, please follow us on social media. But also, before you leave, please, we would really love to get your feedback on today's session. We use the feedback from these sessions in order to improve the education sessions that we do in the future. And we also use them to inform our funders about how their money's been spent and how, what people have thought about it as well. So we'd really appreciate it if you would complete that. But we have a few minutes before 4 o'clock. So if anyone has any final questions that they would ask while they have me, I'm happy to answer.
We've got lots of thank yous and lots of
Thank
this
you.
is great information. And yes, and I very much apologise to all of those people that haven't received the slides, because we have sent them out and it does say that they've arrived at inboxes. So I believe that we're having a security issue regarding your security versus our security. but we will be forwarding you the link to the video and the slides again. Hopefully they'll get through. And we'll also be sending out a page of useful links. So you should receive everything. And if you don't, please email me individually at community@welfarerights.org.au and we'll get back to you on a one-by-one basis. And that should work. And I don't think there are any further questions as far as I can see.
Okay. Well, thank you very much for coming today. I hope that you have found it useful, and I hope that your clients will get something useful out of it as well.
All right. Thanks, everyone.
All right.
See you
Thank
again.
you.